I call this meeting of the Title 40 Study Committee to order here today. Thank you all for coming. Thank you for, particularly for the people I see out there in uniform. We really appreciate your service, and thank you for taking time to come in here today and enlighten this committee. We are indebted to all the committee members who made it today too, and we appreciate Representative Powell and Representative Dempsey and the chairman over here, Jay Powell, and we're just delighted to have you all here today. Terry Long from the Legislative Council down there, and Craig Foster, who's a member of services and helping us with this particular committee. And so it's been a while since we've met, and basically what we've done is to divide this study into two different parts. One has to do with the reclassification of minor traffic offenses, and if you're here for that, I'm not sure we're going to spend a lot of time on that today. The other part of it has to do with everything else that we've decided to take up as part of the Title 40 comprehensive study. And what I mean by comprehensive is it ranges from soup to nuts, as does Title 40 range from soup to nuts. But the things we want to concentrate on here today are actually a couple-fold. One, we want to talk about the driving schools. We want to talk about traffic safety in general. We want to talk about things that are specific to things like interlock device and things like that go along with traffic safety, and look at the possibility of legislative accommodation for some of the things that might come up through the data that's being represented here to the committee. So we welcome you all today, and we're going to start this morning. I wanted everybody to hear from the Governor's Office of Highway Safety in terms of their view of where we currently are. And Harris Blackwood, the director, is here, along with I wrote your name down, but I don't forget. Oh, Spencer Moore. Spencer. Deputy Director. I'm sorry, Spencer. You know, I better put my glasses on when I'm trying to figure out who's going where. The Governor's Office of Highway Safety put a report up on the internet, which represents 2011 data, which talks a lot about fatalities and how they come to be in terms of the variables that affect them. I thought it was a good report, and I know that you'd like to elaborate on that and tell us where we are from that standpoint, and then we can see how that would bear on the whole issue of Title 40 and what changes might be necessary in it to affect a better situation there. So, Harris, y'all, come on.
Thank you, Mr. Chairman. Good morning, everyone. My name is Harris Blackwood, and I am the Director of the Governor's Office of Highway Safety. It's an honor to appear before you this morning. First of all, I want to tell you the good news, and the good news is that for the past 6 years, Georgia has experienced a decline in the number of traffic fatalities. In 2006, there were 1,693 people killed on the roads of this state. Last year, that number dropped to 1,234. That's good news. The way I look at that, that's about 350 people who get to spend a Christmas, a birthday, another time with their family. And we're grateful to the men and women in law enforcement and others who work with us as partners to make that happen. Our number of fatalities for each 100 million miles in Georgia has dropped from 1.49 to 1.11. That number, unfortunately, remains higher on our rural roads. Alcohol continues to be a factor in about 25% of our fatality crashes. This, however, is lower than the national average of 32%. We continue to show a significant number of fatality crashes where seat belts are not in use. However, I'm proud to report this morning that a study conducted this year by the University of Georgia and using methodology that is in use now nationwide show that our observed seatbelt usage is now at 92%. The usage for child passenger safety seats is 98%. We have two areas that we have continued to be difficult for us to gain improvements. These are motorcycle and pedestrian fatalities. There were 127 motorcycle riders killed in 2010. 14 of those were not wearing a helmet. We know that 67 lives were saved that year because of helmet use. And I know there are those who seek changes in our helmet law. Use of motorcycle helmets is saving lives in this state, and I respectfully ask you not to consider any changes as you seek to revise this code section of our law. We struggle with issues of pedestrian fatalities. We are pleased that the DOT is working on improving pedestrian crosswalks along Beaufort Highway, which is an area in DeKalb and Gwinnett counties where we've seen a number of pedestrian fatalities. And this has been a deadly area, and we are hoping that what they're doing is going to make a big difference. And we are seeing pedestrian fatalities all over the state, but that is one area that they have been concentrated in that northeast corner of the metro Atlanta area. In the past 20 years, Georgia has strengthened its laws dealing with driving under the influence of alcohol. We're finding in more and more cases that those who choose to drink are designated a sober driver or using alternate forms of transportation. An example of this is down in Statesboro, where a Nighthawks DUI enforcement unit of the State Patrol was formed after a number of alcohol-related fatalities. An entrepreneur there created a bus service that now runs at night and picks up students from Georgia Southern University, gives them a ride back to their residence. It's an example of private enterprise responding to a need, and it works. I respectfully ask you today not to take any action that would weaken our DUI laws. They're working, and we need them to remain strong and effective. Another area that we are seeing a significant loss of life is among our youngest drivers. Automobile fatalities are the number one killer of young people from the age of 5 all the way to age 34. However, it will come as no surprise that one of the areas of greatest concern is our younger drivers, ages 15 to 19. But I have good news there as well. Our graduated driver's license is working. We've seen a decrease in the number of 16-year-olds who are getting their license and an increase in the number of 17-year-olds. When many of us in this room were approaching the age of 16, we made a mad dash to the driver's license office to get that license on the first day we were eligible. Our students today know the requirements of the law that require experience behind the wheel before that license is issued. So we're seeing a curve there. We're seeing the numbers come down, but it's still an area that represents one of the largest areas of fatalities in this state. We are in need of additional training for new and inexperienced drivers. However, I don't have to tell the members of this committee of our state's fiscal condition. I know there are others who will appear before you today who will speak more to this issue. We are supportive of any efforts that will provide additional opportunities for drivers training, but we don't have any answers for you in terms of how we are going to pay for that. We know that distraction plays a role in teen crashes. We have strong laws that prohibit cell phone use of any kind by those under the age of 18. That law is working, and we ask that you keep it intact. There are also limits on the number of non-family passengers for new drivers, and it is my understanding that there are those who advocate extending that time. There are distractions within the car that we have no control over, such as how loud the radio is played. But limiting the number of passengers is one way we can reduce distractions, and we applaud any effort to reduce that during the early stages of driving. Mr. Chairman, I want to take a moment to tell you about one of the most exciting developments in our office in a long time, and that is our Governor's Commission on Teen Driving. Earlier this year, we sought applications, received nearly 200 applications statewide, and recommended 22 people to Governor Deal to serve on this Governor's Commission of Teen Driving. These are some of the best and brightest high school students from around our state. They have high goals and aspirations that are so worthy. And the whole idea is we've got to develop a message that reaches teen drivers. And that's the question that we scratch our head about, as does every state in this union, as does Madison Avenue and the advertising people, because they don't watch television the way that we watch television. They don't listen to the radio that we listen to. They don't make purchasing decisions the same way that we did when we were that age. They will advise us on messaging to teens, which is a conundrum for marketers everywhere. They will be preparing an initial report by April, and we hope that perhaps your committee will receive them as a visitor during the upcoming session when they come to Atlanta. I think you're going to be impressed. If you have any doubts about our future, ladies and gentlemen, I want to tell you that this group will light your fire. They are great, and we are excited about what they're doing. They are energetic. They want to make a difference. Many of them have been impacted by fatalities of their peers. Many of them have been impacted by the fatalities involving family members, sometimes involving drunk drivers, sometimes involving texting and driving. They have a passion for this that I have never seen in young people, and I want to tell you that's the most exciting thing we're doing right now, and I hope it will be something that will continue. It is a great opportunity for our state. And I want to tell you this. Our counterparts in other parts of the country are looking at us. We're the first in the country. For example, the state of New Jersey had a teen driving commission that had 21 adults and 1 teen. We have a teen driving commission that is all teens. And we have some adults in the room sort of acting as guides, but they're setting their message. They operate in their own. We give them some guidelines, but we're believing that they're going to come back with messaging to us that could really make a difference in reaching teen drivers in this state. Speaking of cell phone use, our current law provides for a set fine for those who are charged with texting and driving. The new federal transportation bill, known as MAP 21, has a requirement that states have an increased fine for additional violations. We are just getting the information on this, and we'll be coming back to you in hopes of creating a higher fine for repeat texting violations. This would open the door for significant federal funding for education and enforcement efforts on texting and driving here in Georgia. Let me say that we're holding our breath as we enter the final 50 days of this year. We have already lost 1,000 lives on the roads of the state of Georgia, and we're entering the heaviest travel period of the year. Our law enforcement partners are redoubling their effort, and we will announce next week a 40-day campaign to limit the number of deaths and hopefully go for a 7th year of reduced fatalities in our state. But with falling gasoline prices and improvement in some sectors of the economy, we are seeing more motorists on the road, and we believe that will be true during the holidays. We're hopeful of keeping our 6-year record of reduced fatalities intact. Let me again commend you for reviewing this vital code section, and we'll be happy to work with you in any way to make improvements that will benefit all Georgians. And that I'd be happy to take any questions you might have.
Okay, any questions from the committee for Mr. Blackwood? I don't see any. Maybe we're not engaged on this. Maybe the report was so complete that it was good. It sounds like a good story. And the question I had was, how does this compare to states of our size in terms of fatality rates? And I know you did that per 100,000 mile too,
Sure.
which is maybe a better indication.
Well, right now, just to give you an example, we are number 5 in the country behind Texas, California, North Carolina, Florida, and us. And that's not the exact order there, but we are number 5 in the country. We drive more. We have more fatalities, for example, than New York, Illinois, Michigan. And the reason for that is they have so much public transportation there. But we drive a lot in this state. We have a lot of cars on the road, and the number of miles we drive is high. We would like to see that number come down. I want us to set a new record here in the South, and that's something we're very anxious about.
So we're number 5 in terms of actual fatalities?
Fatalities, that's right, in terms of pure numbers.
Okay. All right. And states comparative to us in terms of population, 9 million population?
North Carolina is similar to us. They're a little ahead of us. New Jersey's similar to us. They have fewer fatalities than we do.
I noticed that the new law that allows us to that increases the fines, penalties for pickup truck usage had a distinct impact on your numbers in terms of restraint.
It brought us up. We're now 92. Last year we actually did an observation and had 93%. We're down 1% this year, and we're not going to quibble over that. But we are seeing that law is having an effect. And I don't think it has been I mean, there has been no great public outcry that I have noticed. You may be hearing from folks, I don't know, but and we're seeing good seatbelt usage, and I think we're raising a generation now that has had a primary seatbelt law all of their life, and they are using their belts. Believe it or not, the one place we're seeing some decline in seatbelt usage is high school students. And again, we're scratching our head as to why. It's part of that whole idea that they are invincible, that it's not going to happen to me, I don't need it, or whatever. The other place we're seeing a problem is after 9 o'clock at night. The number of fatalities and crashes after 9 o'clock at night grows incredibly. Over half involve not wearing seatbelts. And I think sometimes people have that attitude. Well, they're not watching now. Let me tell you one thing we are doing, and we have been a leader in this. We are doing nighttime seatbelt enforcement. We set up a bank of lights that are generator operated, and we observe them before they reach a traffic stop. And if we observe them not wearing their seatbelt, which you can do very easily, we radio to the traffic stop, and they are written a ticket. And we have been a pioneer in that, and it is working well.
On the thank you. That makes a lot of sense to me. On the distraction issues in terms of, well, let me go first to the DUI issue. I noticed in looking at your report that it would seem that the number of alcohol-related fatalities was down a little bit.
It is.
Is that right?
Yes, we've come down. We're down around about 24%, and that's at the .08 level.
Mm-hmm.
There is what's called the old definition, which was any involvement of alcohol, and that goes on up a little bit to about 33%. But we're about 24% right now, and that we'd love to see that number come down, but I don't know that that's that may be a number that may be our benchmark.
Where I was some testimony later on about the impact of interlock devices. You want to comment on the effectiveness of interlock devices in terms of curbing?
I think there's
numbers?
no doubt that they work. The only problem that we're seeing is that, I mean, this is anecdotal, but there are some people who will purchase a clunker, if you will, and they put the interlock device on the clunker and drive their fancy car or whatever other car they might have. And the other thing is you've got a lot of people in some other states have different laws, but you have a situation where maybe somebody drives a work truck. In some states they're requiring that it's on every vehicle, and that's the only problem that we're aware of, is that some people are kind of skirting the law, if you will, by putting it in one vehicle and driving another.
Another question I have is on texting, distracted driving offenses, and effect on highway safety. Have you seen? I mean, it's too early probably to get an understanding of what that is, since we just passed that law 2 years ago now.
Yes,
yeah. But do you have any comment on enforcement of that? I mean, to me, the enforcement was a big problem in terms of how you're going to get that done.
It is difficult to enforce. I mean, do you look that much different dialing a number on your phone than you do sending a text message? Probably not, and that's the argument that a lot of people make. And we are seeing some cases, but it is difficult to enforce any way you want to do it. We are looking at we will have the first money that we can dedicate toward enforcement and education, messaging on television and this sort of thing, that coming later this fiscal year. The Congress passed this new federal transportation bill in July. We are just starting to get some regulations, and some of them are just being advertised in the Federal Register and won't take effect until the middle part of this fiscal year, sometime around March or April, and we won't have any money until later in the year. So this is all new to us. It's the first time, because it took there were there were multiple extensions of the old bill, which was passed in 2005, and had expired and had extension after extension after extension. And of course, this bill was passed in July and lasts only 2 years. So we're kind of holding our breath, and we also don't know what effect, if any, the current fiscal situation in Washington is going to have on our budgetary situation.
You and probably an awful lot of others.
Oh, yes.
It would be my guess. It seems that from your testimony that the one thing that you did recommend was this number of other passengers, some more aggressive. Can you be more specific on that in terms of what we see?
I know there's been some discussion among a number of groups, and some of them will be appearing before you. I'm sure that, right now we have a 6-month window where only family members can be the passengers in a car. We can't control, Mr. Chairman, how loud they play the radio or whether they're adjusting their makeup or their hair and all the other distractions that are out there, plus the outside distractions. But if we can limit the number of people who are in the car, sometimes peer participation, peer pressure becomes a problem. And we're asking a young person to handle 2 tons of steel that they're just getting used to driving. Whether that extends through their 17th year, that's a decision that rests with you, sir. But anything we can do to make our children safer. I have, one of the hardest things I've done in this job is to go around the state and you visit with parents. We currently have a young man, Caleb Sorahan, who's the namesake, and he was killed at texting and driving. His mother, his sister, his brother have become passionate advocates for us, and we use them at every stop. But I see the sadness in their faces when they talk about that. He died on the 15th day of December, and that ruins Christmas every year. And we've got to stop burying young people. That's the bottom line, sir. Is we have got to, we are sending too many young people to an early grave, and so many times you read their stories, and they were the best and brightest in their class, and they were heading to college or they were in college, and it is that young life is snuffed out and never reaches its potential, and that's any tool we can use, we welcome.
Okay. Are there any other questions for the director? Okay. Katie?
Thank you. That's great. Very informative. I know at my way, we lost a young man several years ago that there was legislation passed. I believe Joshua's Law.
That's correct.
And I just wondered if the teens that are on this panel, if y'all have heard from them some concerns about that, about the possibility of drivers training and the advantage.
They have talked about, we haven't gotten real deep into that yet.
Mm-hmm.
We had kind of an organizational meeting in October, and but I've heard some of them say that they have had drivers training. Some of it is private, some of it is provided by local law enforcement agencies. Some of the colleges are doing it as continuing education. But the problem comes in that we did have money at one time that was earmarked for that, and that money is no longer available to us because of budget constraints. How we do that is a question that rests with the General Assembly, but we need every dollar we could devote to drivers training. Sometimes even $300 for a course is out of reach for some folks in this day and time, and sometimes there's a need to have that teenager to be a driver because it involves, sometimes parents are working 2 jobs and they've got to get the kids to other activities.
Well, his mother is a neighbor of mine,
Yes,
and I
ma'am.
know that it's still very, very strong on that family's hearts that legislation was passed. And then the times came in and, certainly affected the spending that was available for it. But I think we need to do all we can to strengthen that component.
You have my full support in that, ma'am.
Mine too, so you let me know what I can do to help.
Sounds like a mutual agreement society here. So, along those lines, is it not true that the primary use of the funds that came from Joshua's Law that were applied through GOHS in terms of the grant process, right?
Right.
Were applied primarily for cars, and
That's right.
That type of thing to support the driver education effort. Is that right?
And I serve on that commission by virtue of my position, and the only thing we have done to meet is that somebody quit using a car because they had to close down their program because of funding, and we allocated the car somewhere else. I mean, that's the sad part of this, is that what had been there during a little bit better times, we had to allocate that car to another school who could use it. And there are some schools, I have been to some schools, high schools, that are having driver's training at school. The local boards of education are picking up the funds for that, and we applaud them for that. But there are others who just can't afford it.
Are there any recent data points or surveys that indicate the relative success of driver education versus no driver education with regard to accident data?
Well, I don't know if you can credit driver education, but I think our graduated driver's law, we are seeing the numbers are coming down. We have seen a significant reduction. It has mirrored the reduction we've seen in fatalities in the state, which is wonderful. We had about 127, I think, last year, and it is, that's 127 too many. And but we have been much higher than that, upwards of 200, and we are, I think that the fact that we are requiring some time with parents behind the wheel, and of course that's self-verified, and that's that's one of those problems. Is was it really the required hours, the 40 hours? But we know that getting the delay in getting them behind the wheel, and with that some time of gaining experience, is certainly helping, and we need to continue working in that direction.
Just point of information, I think when you mentioned the cost of driver education, actually it's a pretty good bargain. I think you probably agree, because of the 10% reduction in insurance.
Sure.
Plus the tax credit
Absolutely.
that people seem to forget about in terms of, and that almost equals the cost of the driver education portion. Any other questions for turn that off?
I'm trying to
Okay.
turn it off and it won't go off.
There. I think we got anybody else? Well, look, thanks an awful lot for coming and giving us that complete report. We really appreciate it. Thank you for what you're doing for traffic safety on our highways in Georgia. You did a good job, and we applaud that effort.
Thank you,
Harris, you're going to stick around, are you not?
Yes, sir.
Okay. We're going to move to a kind of a panel discussion of these issues that we kind of touched on already this morning. And we're going to invite Ron Jackson. Ron, where are you? Someplace back there? Okay. Ron, from the insurance side, and public safety is going to be represented by the Colonel. Okay. All right. Yeah. Craig just reminds me that that we do have David Contreras from Guardian Interlocked here. If you want to come up, and also is anybody from MAD here? Don't see him. Okay, all right. Well, the purpose of this is to really to get you good people to comment on issues that are of interest to you. And of course, we've already heard from GOHS on these, but it goes to one of the issues that I'd like to just kind of start out with, and that is the number of people in the car with a teenage driver, and if you could comment on that from your perspective, Colonel, or do you want to start with that?
Mr. Chairman, I've got 3 teenagers. My oldest is 18, and my twins are 16. And as a point of comedic relief, I'd actually like the law to be the exact opposite, that my kids aren't in the car together, that there's somebody else, because especially that twin dynamic, to me it makes common sense today that the maturity level of the kids today is not what it was generations ago. Now, folks can argue about that, but as a parent, when I look at the maturity level of my kids and what distracts them, to me, it is best to distance themselves from the distraction and peer pressure that comes from having their folks of the same age in the car with them. So it stands at 6 months. I would be in support of distancing that even further because there's a big difference today between a 16-year-old and an 18-year-old. And my dad used to say that if you're out after 12, you're up to no good. And it seems like today, when you get some friends together of a certain age, doesn't matter what time it is, they're up to no good. So, with all of that, kiddingly saying that as a parent and what I do in this job, anything that we could do to distance that time, I think would be a very positive thing.
Okay. Anybody else want to comment on that, Ron? Or anybody?
Mr. Chairman, Ron Jackson with the American Insurance Association, and we certainly support the committee's work and considering ways that Georgia can improve. As Harris mentioned earlier, graduated driver's license program has had a very good effect in Georgia. We think there are improvements that could be made. One would be during that intermediary period where under your second year of licensure that you can have up to 3 passengers in a vehicle. We think considering reducing that down to 1, studies have shown that has shown market improvements. Reducing just to 1 teenage passenger on average reduces collisions and accidents by 7%. Reducing it further, is some 15 odd states have prohibited it entirely for at least an initial period of time. Have seen reductions of 20%, but it is true that those younger drivers, when I was reading some of the material and reflecting about the brain not developing, and it struck me that for some of us, and maybe you've got the misfortune of having one of them testify before you, maybe the brain never fully develops, but it's definitely true at 16 to 17 that these kids are more distracted. And AAA studies have shown that with each additional passenger, the likelihood increases for crashes. By the time you have 3 or more, the likelihood is quadrupled. And so further restricting that until the drivers reach 18, we think would be beneficial.
Okay. Any other comments on that, David?
Although my area of expertise is ignition interlocks, I have just graduated a 16-year-old son from driver's education in May of last year, and he has his license. He's about to get his the ability to have 1 more or 2 more passengers in the car. If there's a quorum here to raise it to a year, please do so. It's not that he's or that any of the friends are bad kids or distracted kids. It's just, this gentleman is right. That brain doesn't fully develop until a few years after 16. Again, as a parent, the law is fantastic. Keeping them from driving with others is fantastic. Going up to a year would be beneficial.
Questions for panel on that particular issue? I always have a question. The data that you cited, Ron, in terms of the percentages that you mentioned, where do they come from?
Well, there's numerous studies, and you should have in your folder, representatives, a sheet titled Graduated Driver's License Legislation Improvements in Georgia, and you'll see some of the statistics I mentioned there. Some of those figures came from a AAA study. The Insurance Institute for Highway Safety has conducted numerous studies as well. Some of those have a few years on them, but we'd be happy to get the committee information from those studies, and actually the Institute has testified before other states that are considering reducing the number of passengers and making some of these other graduated driver's license improvements, and have calculated possible improvements for specific states. And if you were interested in communicating with the Institute and possibly getting some Georgia-specific data and estimates derived for your consideration, we'd be happy to facilitate that.
I think that'd be great if you could do that. That'd be super. You're talking about this sheet here,
Yes, sir.
right?
Yeah.
It's pretty remarkable percentage change in some cases. Well, in fact, in all cases. From 71 to 85% with 3+, and from 30% to 46%, depending on the speeding environment. That is significant change. Harris, could you translate that into what that would mean if we, on those, I don't know, do quick calculation if you can?
No, sir, but we'll get that number for you.
Okay.
Yeah, Mr. Chairman, I think there's some studies that are somewhere between 10 and 15% of all your accidents are caused by teen drivers, and they have a disproportionate impact on the accidents on the roadway.
Okay.
And those numbers did come from NHTSA's information. We'll try to get that information to you.
All right.
In all seriousness.
All right. Okay. I don't see any other questions on that particular issue. I know that that's been brought up on a number of cases. I think the insurance business obviously is interested in lives, but they're also interested in the monetary effect on the business of insuring those particular accidents, and that's a worthy thing to be concerned about. Obviously, it's not all just sweetness and light. The second thing that we want to talk about was David, goes more to your area of concern, and that is the interlock device and relative effectiveness of that, and whether or not this committee should consider a recommendation to require either one of two things to occur at 0.15 or more requirement for a mandatory first-time interlock device, or a secondary opportunity that would be basically couched on the 0.08, but an option at 0.08 for the driver to either put on an interlock device on a first-time basis or suffer the penalty, one or the other, in terms of a probation of the offense. Tell us how you feel about those, and anywhere you want to start is fine with me. Colonel, you're smiling at me. Somebody that smiles at me, Colonel, has obviously got something on his mind.
Well, it's interesting as we talk about first-time offense, but statistically, the person has committed the offense 88 times before they were caught the first time. 88 times they committed the offense of driving under the influence before they were caught the first time. So, I look at it and I look at the lives that are lost, and I say very abruptly, why are we having the conversation? Why isn't it automatic that it happens? So my stance would be very strong there, looking at statistically what it takes to get caught the first time. That should be the punishment. And I know that's a tough stance, but anything that's done, whether it's on a graduated scale at 0.15 on a first-time basis, what does it take to get there? And what took to get the person to that point. So we would definitely be in support of that.
Okay. Anybody else want to comment on that?
Well, I want to mirror that comment. Matter of fact, let me pass these out. I didn't get a chance to get them to you prior. But that stat is specifically from NHTSA that MAD publishes in every one of their documents. The number is actually as low as 80 or as high as 500 national on prior attempts to drive with alcohol in your system or above the legal limit. Now, some of those studies are self-studies and some of those are empirical. So 80 is the low and 500 is the high on that specific stat. Now, there are many, many reports out there, and there's a lot of statistics. In this document, what we're going to give you is mostly New Mexico stats because they have the most comprehensive grants available to a gentleman named Dr. Richard Roth, who's nationally known. He's put together most of these numbers. I'm going to go through just a little bit of just a few of them, if you don't mind. Again, first offender is not a first offender. The first time caught means they've driven at the low number 80 times prior. What's interesting is the BAC statistics mirror that of the first offense, mirror that of second and third offense, which means the BAC time or caught, or the BAC at the time of arrest is the same. From, you'll turn to page 2, between 0.08 and 0.16, that curve is exactly the same. So if you get caught at 0.08 to 0.16 in a first offense, you're going to get caught pretty much at the same level at a 0.08 to 0.16. That means there is no hard evidence saying that 0.16 is the magic number or 0.15 is the magic number. It's pretty consistent throughout the data. Pretty telling stat. We can get into recidivism, but to me, those are the telling stats. How many times have you done it before your first arrest? And what is really the first offender acting like at the time of arrest? It's kind of acting like the same. He's kind of acting like a second offense and a third offense.
Mr. Chairman, if I may.
Sure.
You know, as I mentioned when you asked the question earlier, and that is somehow I think as we do this, we've got to tighten up the language in terms of what car that it's put in. You know, if a guy has a work truck that's owned by his employer and that's the vehicle he's in most of the time, and he has an opportunity to stop in that car on his way home at a bar and gets drunk and kills somebody, then the interlock has done absolutely no good. We've got to make sure that we identify somehow or another the primary vehicle they drive, because there are too many people who go out and buy a 25-year-old car for next to nothing, put the interlock in it, and the car that they drive most of the time is not measured in any way. How we do that is, you know, I think it can be addressed in the law, but that is a problem throughout the state because I think if you talk to some of the providers, they are putting them in. I mean,
we are putting them in multiple vehicles. The machinery is so sophisticated now that multiple vendors can take one head unit, put it in put base units in multiple vehicles, and that person not be able to drive the alternate vehicle because it's locked out. So that can be addressed. Distance between, I mean, here in Atlanta we can put 100 stations and everybody find an interlock company tomorrow or today. South Georgia is probably a little different. That's not a concern anymore. Because of the way businesses run, the availability of the interlock is there, and the technology of the interlock is there to accommodate multiple vehicles and multiple programs.
What's the cost of all that?
I love to say this, sorry about it, but it's 2 beers a day. It costs about $2.35 a day.
Okay.
Depending upon which vendor and which model. I didn't say at a bar. I didn't say at a bar. There's no happy hour anymore, so.
Yeah. Yeah. So how's your interlock working today, right? I mean, it's a kind of
exactly. Very well.
the next question.
I think one of the important stats and the important things to talk about, though, is when you get your interlock. Circumvention, which whether by driving another vehicle or getting somebody to drive you around or just not getting it, is a big deal. Map 21 addresses that. The federal government addressed that. They want it on as quickly as possible. There is no more one-year hard suspension. Okay? Last year we went down from a year hard suspension to, I believe, 120 days, which takes effect on second and subsequents on January 1st. We're not talking about second and subsequents. We're talking about first offenders. The argument is always made that these aren't really, if we throw away the 80 number and say now there's an interlock on a first offender, and let's say he or she is just a first offender, okay? What are they going to do? The demographic of that is they screwed up, we're going to fix it, how do we fix it? You mean I got to wait a year to fix it? No way. I want to get this on, I want to get this over with right away. I want to get back to work. That's why it's reduced. Because the first offender is a different demographic than the second and subsequent, we feel that bringing it back down into a no-wait period is beneficial.
Take me to page 5 here in the chart that says status of state ignition interlock laws.
Yes.
And you got a list here that says mandatory with, is that 08? Yeah, 08. Mandatory with 1.5.
Correct.
Mandatory with second conviction, which is us.
Correct.
And in the last one, I guess it says not mandatory. Just looking down the list, it's kind of interesting because it's all over the lot here in terms of where these
pretty much is
states are. You can't say demographically.
Well, I think what you can do though is
Louisiana's.
More often than not, in the administrative states where it is a function of license reinstatement, it's mandatory at 0.08. Then it becomes a little bit of a hodgepodge where it is judicial in nature, and then it goes up to 0.15. And then certainly at mandatory unjudicial, that's again a little bit over the map there. But on the first offense, where it's, and that's about 90% of them, if it's an administrative state, a rules state, then it's 0.08. Then it becomes unclear at 0.15. A little less paperwork for the DMV.
Okay. I mean, so the idea of that's been brought up before of a probationary sentence, when the judge probates the thing, it says, look, you can either do this or that. You can either put an interlock on, or you can just go, take the penalty, or whatever combination of options that he might do. He might send you to DUI school as part of that. He may send you into the rehab program that we've got here. The question I have is how do all these things work together in terms of the drug courts and that type of thing?
Well, I think they work in concert together. I don't think interlock is the sole reason treatment would be accomplished. I think working with the driving schools or the assessment facilities, tandem by a probation office is necessary. I don't want to say rehabilitation, but for treatment, if that's the goal. Absolutely, we don't want to interrupt any kind of focus on making sure that this individual doesn't recidivate. That means treatment, wonderful. But I think in conjunction, but the one thing that treatment and assessments don't do is they don't immobilize the weapon. Okay, that's the long and short of it. While going through treatment, people hit road bumps. We have a technical device that can read exactly what's going on when they start their car. And we'll supply that data to whomever requests, legally, of course.
Chairman Powell.
This is, I guess, for Mr. Blackwood. How would we go about identifying and making sure that all vehicles that the person reasonably has access to, that we've covered all of those?
Well, as he talked about, there's the ability to change the hit unit from car to car. The wiring and the interlock remains in the car, in the other car, but they can change the head unit from car to car. It goes with the driver.
Well, I guess my question is basically, I don't know, it might be threefold. But at one point in time, before I started sending children out into the world, I had 5 vehicles titled in my name.
Yes, sir.
So we're talking about having to identify all 5 of those that I have access to. Is that what we're talking about doing?
Well, I mean, you could limit your ability to drive those other vehicles. I mean, if your primary vehicle is this vehicle and a work vehicle, and you can say these are the 2 vehicles I'll drive during this probation time.
I think states have done that in saying how an offender must be driving an interlocked vehicle, period. I don't think that's the responsibility of the state or the probation office to make sure that all vehicles have the interlock. Just make sure that the interlocked driver is driving an interlocked vehicle.
So what you're talking about is not identifying the vehicles as much as getting the offender to identify which vehicle or vehicles he will be driving during the probationary period and making sure that those have the interlock device. And then if he's driving a non-interlock device, then a vehicle, then he is in violation of the law.
That is correct.
Okay.
Anybody else? Colonel, I have a question for you. On the interlock situation, I think it sounds like it works. In situations, do you pull over somebody that has beaten the interlock? I guess is what I'm asking you.
I don't have any statistics for that, sir.
Okay.
I can answer that if you like.
Go ahead.
The industry, and forgive me for saying it so late, I do work for Guardian Interlock, but I represent a coalition of interlock manufacturers today. I'm not here for Guardian specific. We have about 5 of us that have gotten together for this. It's about 2% of the time that we find tampering. Now that tampering can be found electronically and certainly visually. There's so much data that is recorded within this device. It's a simple device, but it records everything, from power offs to power ons to levels of rack to levels of engine voltage and things like that. So we can see spikes. That is most definitely attainable, and it's about 2% of the time. So we're really not talking if they have it installed. Director Blackwood is absolutely right. The biggest problem is the circumvention of not having it on. So once you get it on, you really want to get it over with.
Okay. All right. Well, appreciate that information. Is there anybody else that's got a comment, non-panel, on the issue of impaired driving? Everybody appears to be mildly sober here this morning, so that's...
I've got a device to check.
Yeah, it used to be that they had to come back in, the offender had to come back in and have the device checked or calibrated every 30 days. Yeah.
And the law currently, until January 1st, is 6 months of concurrent monitoring in the state of Georgia. All they have to do is really show the monitoring reports. There are violations given to the department, but really all they have to do is show the monitoring reports. That's a very good point. On January 1st, it goes to 8 months, so giving that full year of compliance, 120 days and then 8 months of concurrent monitoring. One of the things that's been very, very effective throughout the nation, Washington, Arizona, all these programs that have compliance-based monitoring, which means simply that. If you're not doing a good job on it, why would we want to put you back on the road? Again, these are highly sophisticated pieces of equipment that can tell when you have blown over the legal limit and when, the time and date. So treatment is absolutely in conjunction with that. So 7 months in, if you've got a guy that's blowing clean, has blown clean for 4 months, great. give him his license back.
Mm-hmm.
Right? 7 months in, you've got a guy that's blowing fails at 6 o'clock in the morning. And I mean fails at .05 or greater, or .08 or greater. Do we really want to put that gentleman back on the road? Don't know.
So it's like a variable sentence or a variable probation period, effectively.
Most of those are, again, administrative states that require reporting and have systems set up to parse the data out. But it is being done on local levels in courts in Texas as well.
That's interesting. So the only way to beat the system is to drink in your car after you've blown the interlock device.
No, there's a rolling retest.
Of course, there's an open container law that deals with that. So
Chairman, there is a rolling retest on it, or a random retest, we like to call it. That you have to. It's a variable time within 5 to 15 minutes every blow.
Yeah.
So it also just want to let you know. I'm surprised I didn't hear the question. What if you get somebody else to blow for you?
Yeah.
We have cameras now. So, although it won't prevent them from blowing, it'll catch who does it.
My guess is that would probably have as much appeal as the red light cameras in Georgia.
I think so.
That'd
Maybe we want to try
be my guess. But anyway, they do their job, don't they, Colonel? Yeah.
But people can do that job better.
That's true.
Yes, they do.
That's true. Well, there are no other questions on that issue. Let's move along to one other that at least from the data that I found, and this came up the first time around, is the issue of driving without a license. I know some of you guys don't have any view of that necessarily, but that is a major problem. But I think your numbers, Harris, why don't you tell? I know what your numbers are. If you don't remember. I think they've actually come down in Georgia, but they're still pretty heavy, and they're probably not representative of the people who are actually driving without a license, and therefore without insurance. Right. Right.
And of course, there are people who will do that, and we know that there are some people who, either because of immigration issues, there's some because of licensure issues, and it happens every day. And I doubt there's a shift that one of our state patrol posts doesn't have somebody driving without a license all over the state. So we just multiply that with 50 posts around the state. It happens. It happens continually. It happens throughout the state. It is a problem, and there are people who decide my getting to work is more important. I want to have a chance of not getting caught. And of course, when they do get caught, they do go spend more time in the lockup. It is a legitimate problem, and it happens. It happens with way too much reading.
Other states have tried different things. I'm not sure from the data that I've read that there's a good solution to this. I know that Washington and Oregon both attempted to zebra stripe the plates of those who were driving without, cars that are related to those people driving may be restricted, and they stopped doing it. They found it wasn't effective.
One tool that is become more prominent, and the state patrol has some, as do some local law enforcement, is the automatic license plate readers.
Scanners.
And they're a lot of times when they lose that license, they're notifying the Revenue Department about the tag as well. So there's a flag there, and that's those things can read 700 license plates a minute or whatever. It's unbelievable. They're operating out on the highway, and they're catching it. Every tag that runs by. But it is a problem. Of course, that also the other thing that license raters are doing is they're describing people who are driving without insurance. So a lot of times they are one and the same.
Right. Right. Does patrol use those?
We do, sir. We've got about 30 of them in the state. They're used for the hotline enforcement. And so for the very same concept that a person's registration of a vehicle to the Peach Pass is on a list that can be monitored, the same thing can be done with people who do not have driver's license or suspended driver's license. They're very, very effective. They are about a force multiplier of between 300 and 400 to 1.
Wow.
In other words, you would have to put 300 or 400 officers on the roadway to run the licenses to get the effect of just one of the pieces of equipment. Technology is a neat thing.
How much does it cost?
About $25,000 a piece.
Wow.
But you'll hear counties say that,
They can make that up in fines.
in as little as a couple of weeks.
That's pretty compelling. That's pretty compelling. Okay. Anything else that comes to mind that this August, moving towards September panel, they can help address with any of these issues? Seeing none, I want to thank you for coming in today and presenting these things. We're going to take all this into consideration as we come up with the recommendations for the study committee. I think there's some good information here, and there's a lot of good information here with regard to both the impaired driving and the distracted driving issue. I don't have any solution for the driving without a license thing. If somebody's got any good idea on that, that would be well worth hearing from you as we go to the public comments later on. Okay, we're gonna move. Thank you so much for coming. We really do appreciate it. We're gonna move ahead. We're going to start this discussion on the driving school issues, and for the committee's purposes, just let me say that Representative Powell and I, you and me, in the Motor Vehicles Committee, had looked at been looking at these issues over the years, basically, and attempted to come up with some reasonable way of trying to balance the interest here of better driver education, better school environments, and to manage the costs of these things and varying interests. There were bills introduced last year that we decided not to move on. 2 of them went to Judiciary, 3 of them went to Motor Vehicles that bear on this issue. But as I told the committee members in my email, this issue is really one of effect of competing interests on the let me get my stuff together here. Competing interest on particularly on the private schools. My comment to start with is that the private schools occupy around 3,500 employees across Georgia, and they're a small business, but a small business has basically been created by the needs that the state has seen for improved driver environments. And so what we wanted to do was to hear more about that issue. We heard from Barry Schrank, representing the private school owners last time, and we have a few more people here who want to speak on that today. But Barry, why don't you come on up, and Bob is representing the GUARD organization. He's president of GUARD, and we appreciate your time today, and thank you for coming. We are going to have some representatives from other organizations who supply these types of classes, and we'll get to that after we hear from Barry and Bob. Just to set the stage, I'd ask you for some data, for some other information that you provided in terms of validating your prior comments on. But why don't you just brief us on kind of where bring us up to date, I guess, is the point.
Good morning, Mr. Chairman. Mr. Chairman, I'm always everywhere as the chairman, I think. This
Put your microphone a little closer, Baron.
Can you hear me now?
Yep, can hear you now.
Good. Okay. Good morning. My name is Barry Schrank. I'm president of Taggart's Driving School. I'm a member of GARD, which is the Georgia Association of Risk Reduction and Defensive Driving Educators. As the chairman pointed out, Bob Haynes is our president, and he is with me today. Just a quick comment before I get started. Chairman Rice mentioned that there's a 10% discount for taking driver education, completing a driver education program. Actually, there's more of a discount because under the law, if you have a B average or above, or you're in the upper 20% of your class, you get a 20% discount on the insurance. And with a $150 direct tax credit for the completion of the program, basically that pays for the driver education program the first year. And of course, the insurance reduction goes on as long as the teenager has a clean driving record. Also, with respect to the number of students, or the number of passengers, I should say, in a car, I would suggest to the committee they may want to take a look at the Johns Hopkins study that was completed a couple of years ago with respect to the number of individuals in a car with a teenager and the increased chance of an accident. It's eye-opening information. I believe it's a definitive study. At least a lot of people in traffic safety refer to it as a definitive study, and will give you good information on that particular subject matter. As Chairman Rice indicated, he had asked me for some additional information, which I believe he sent out to the committee members about some of the comments that I had during the last time I testified. And if anyone has any questions, if anyone's had an opportunity to read that information and has any questions on that information, I'll be glad to answer those questions directly.
This is the stuff. These are the materials I sent out on the pretrial diversion program in DeKalb, and the website in DeKalb. And I also sent out this, which was your response to the questions I had in terms of.
So both memos that I sent you were sent to committee members?
Yes. Let me see the other one in here.
Okay. Basically, with respect to the example that we have used with the court system becoming involved in operating driver improvement programs, we use the DeKalb County Recorder's Court as an example, and I have provided a URL for that particular program. All the information is on the web, and basically, as background, for years and years and years, judges have used the system under judicial discretion, which we support, whereby if someone got a traffic ticket and it wasn't for a serious violation, like passing a school bus or reckless driving or something like that, the judge would allow the individual to attend a licensed 6-hour defensive driving program, take that completion certificate to the court clerk sometime Monday through Friday during the normal working hours, and there will be a court cost assessed, and then the judge would non-process the ticket. The ticket would not go on the person's record, on their driving record, and of course the person wouldn't have to take time off from work and appear in the court. It worked out well for the court system because in a lot of the small courts, with the number of tickets that are issued, the judges really can't handle the number of people that want to appear before them. And they will often make the decision, the person has received a ticket, that they would rather go to the driver improvement school and pay that fee, which is $75, which is set by law, and then maybe on their lunch hour go over to the court and pay the fee and then have the ticket dismissed. A lot of the judges that I have talked to like that system because it also gives the person who got the ticket some education about traffic law, rules and regulations, and defensive driving techniques, and hopefully that'll keep them from violating the law in the future. As an instructor in those programs, I'm no longer amazed because I've been doing it for so many years, but we still have a lot of people who really don't understand traffic law or what the law says they have to do or should do until they get a ticket. And so we believe that education works. Basically what has happened over the last few years, the court systems have decided to get into the business of operating driver improvement schools. And so now what happens basically in DeKalb County Recorder's Court, if a person comes before the judge will offer them, instead of a guilty or not guilty plea, they will offer them a similar system to what had been in effect, except that they will assess them $300 to join the courts program, and then they will pay $65 to take the courts driver improvement program. We believe we had resolved that problem last year with the passage of House Bill 269, but apparently we haven't, because the judges really have found a way around it and continue to operate those programs. For well over 30 years that I've been involved in traffic safety and working with members of the legislature on various driver education, DUI risk reduction issues, driver improvement issues, it has always been clear in my mind that members of the legislature were interested in having a public-private partnership to operate these programs. Other states operate these programs with state employees. It was pretty clear it was a lot less expensive to the state and the taxpayers to have private industry operate these programs. And that's the approach that I have seen the legislature take year after year after year. So to be honest with you, we're here because we have a problem, because it's encroaching on our business and we have no control over it. As a taxpayer, I really don't think it's right, if there is such a term, right where the court systems are getting into private industry or operating private businesses. But in effect, that's exactly what they're doing. And so that was the information that I provided with the URL. The information is public. You can go on their website and look at it. You can go to court and sit there and listen to how the judge handles the offender. And basically, I think it's just a way for the courts to raise funds. What they're doing in DeKalb County, and maybe doing in other jurisdictions, is assistant district attorneys are teaching these 6-hour defensive driving courses, as well as, according to what the information is provided on the website, they're teaching GED courses and other things. Again, as a taxpayer, I question whether that's a good use of an assistant district attorney's time, especially when I read in the paper that last year the governor put additional money in the budget so different jurisdictions could handle additional assistant district attorneys so that they can prosecute criminal cases and get rid of some of the backlog. But apparently, some jurisdictions do not think that's a good idea. So basically, that's a problem that we have. I think the code section is pretty clear, but it's not clear enough. I talked to Chairman Powell at the conclusion of the last meeting and gave him the language that was in the bill in 269. And I believe, and I'm not speaking for Representative Powell, that there was enough ambiguity in that language that the judges can continue to do whatever they want to do. So we're just asking for some relief. At the last hearing, Judge Jackson from the city of Atlanta testified that what he does is gives a hint, shall we say, to the offender that they should attend non-licensed courses, such as what is offered by AARP to their members. I believe under 40-5-82, parentheses, little b, end of parentheses, that's clearly against the law. And that law has been in effect for 15 years. One of the series of bills that have been passed through this legislature and signed by the governor over the years. I cite Judge Jackson only because he testified, and that's what he does. But other judges do the same thing. I really think that most of the judges follow the law, because we have members all around the state And when they tell someone that they have to take a course, they tell them to take a license course. But it is a problem, so we're bringing it to the attention of the committee and asking for some assistance with this problem. Are there any questions on that particular subject?
I don't see any yet. Okay. Chairman Goley? I got you. Did you get it?
Is it on now? Yes. It
Yes.
is.
There you go.
Thank you. Just for clarification, any course, defensive driving course, or any course that may be part of a pretrial program that really is administered by a prosecutor, on the felony side, it's really run by the DA and, of course, the solicitor on the state courts. I mean, any sort of course that may be involved. And of course, in rural jurisdictions, where you don't have a state court, it's going to be the DA who's running any sort of pretrial program for anything and everything, right? Any course that we're talking about, regardless of who it's administered by law, has to be, if I'm using the right word, certified, approved, authorized, whatever it is, by DDS. Is that a correct statement?
If it has to do with driver improvement, if it has to do with DUI risk reduction or drug use, it's supposed to be licensed and monitored by the Department of Driver Services. That's correct. And other courses, like a GED course, I'm not that familiar with all the codes.
What about just your rank and file defensive driving course?
It's supposed to be under 40-5-80A1 and 82, a licensed course licensed by the Department of Driver Services.
Okay, so the answer to the question is yes. Any sort of course that's out there,
Yes.
defensive driving on up, has to be authorized, approved by the DDS. Is that that's
That's my understanding.
Okay.
That was the legislative intent, I believe, that I have seen over the years.
okay? And I understand you're not with DDS, but I mean, this is getting into courses that are approved, not approved, and you've made some statements. I just want to make sure I understand. First, I want to have a base understanding of any course that's out there, whether it's basic defensive driving on up. If it has to do with driving a car, it has to be certified
Driver's license.
by DDS. Okay, thank you.
And that applies to the instructors also, right? Do they not have to be
The
certified?
instructors all have to be licensed by the department. They're licensed after a background check. They have to submit an application. They have to submit fingerprints to go to the GBI and FBI. They have to receive a certificate from the curriculum provider that they have been trained and are authorized to use that particular curriculum. And it has to be for a curriculum that has been approved by the Department of Driver Services. There are about 5, maybe 6 approved curriculums that school owners can use. And in addition to that, these courses are monitored. Every once in a while, someone will show up, monitor from the department, and they go through all our records to make sure that we're not, in effect, selling certificates out the back door for license restoration, ticket dismissal, points reduction, insurance reduction. And sometimes they will sit outside the classroom before the class starts to see whether or not we let people in late. They will be there at 9:30 or 9:15 to make sure that we don't let people out early. They will often sit through a class to make sure it's being taught as a curriculum requires it's being taught. So it's very closely monitored, and it should be. We haven't heard many stories recently, but it's not I know that if I wanted to sell a completion certificate for one of our DUI programs, I could probably stand in my back door after it's dark and sell a certificate for $1,000 or $2,000 for somebody who's gotten a DUI and needs a completion certificate to get their license back. And I don't know what the going rate would be for a 6-hour defensive driving course, but they could also be sold. That's what the problem is, and that happened over the years. But the House Motor Vehicle Committee over the years has looked at that and basically has passed enough legislation that is rare if it happens at all, where somebody is selling certificates. But one of those certificates is pretty valuable. If you're going to lose your driver's license and for some reason you delayed, you're supposed to have that certificate in at a certain date or time. Or maybe you're supposed to have that certificate in on Tuesday morning, your probation officer, and or you're going to jail. And you came to class on, say, a DUI class on a Saturday, but then you overslept on Sunday morning because you stayed out too late Saturday night, and now you need a certificate. You know you're probably going to jail on Tuesday. So there's, you just have to have a lot of control, and that's the way it is around the country.
Other questions with regard to these court-ordered classes or opportunities? I'll get to you, Judge. I understand. Let's make sure we separate these issues out.
Okay.
One are the defensive driving courses and the DUI courses and things like that can be taken for point reduction and insurance reduction in terms of the defensive driving courses. The DUI courses are obviously rehabilitative type courses that are ordered by the court. And then the whole other side of your business model is the driver training, right, driver education courses. Now, we saw in earlier testimony the Department of Driver Services provided a look at that from the business standpoint of the decline in terms of the number of students in the driver education environment. And as increases occurred in the 40-hour program and the virtual training, those types of things, there were increases in that, but your business model effectively declined. And the concern that I have as chairman and for the members of the committee is that the 3,500 people that are involved in the private school business not only do things that are appointed by the court or influenced by the court, but they also have this driver education thing, which is really a salient in terms of our safety issues. So the question the committee has to answer for anybody who wants to testify out there is, how does this business model continue and be effective in terms of public safety with regard to these courses? And so both of them tie together, and constraints or unfair competition, if you want to put it that way, whatever you want to call it, can influence both sides of this business model. And so we want to be careful as to how we look at that. But at the same time, we want to make sure that it's maximizing the number of people who do have the opportunity to get this type of training. So what I'd like to do, I'm going to hold comment on the first part of this that has to do with the judicial side until Barry, I'd like to have you testify on the driver education portion of this too, in terms of the other schools that are in, other people who are providing that type of thing.
Okay, just to clear it up, there's really three parts to our business model, and each part requires a separate license from the Department of Driver Services, and each part, not only a license for the business, the school, but also for any instructor. So, for example, I have a license from the department to teach driver education and adults how to drive in the car. I have another license to teach a 6-hour defensive driving course. I have another license to teach a 20-hour risk reduction program. And actually, I have a fourth license that allows me to be a third-party tester to test students that have taken our driver education program and provide the road test to them. Give them a completion certificate, which they then take to the Department of Driver Services, basically walk in and have their driver's license issued as long as they have all the other documentation they need. So there are four parts to the business, all of them licensed, all require separate bonds, all require separate background investigations to operate those four businesses. So, okay, a problem that we have also had over the years is the operation of driver education programs. I say we, the private industry. The operation of private driver education programs by public high schools after school, and selling those programs, if you will, or setting the tuition at less than cost. We're all adult business people, we pretty much know what it costs to operate our businesses. And when a school system provides a driver education program after school for less than what we know costs are and competes against us across county lines, going after private school, independent school accounts, we have a problem with that. And so we have introduced or had introduced legislation that would require any school, public school, that offers a driver education program outside the school day, whereby they're not using, it's not a QBE funded program, that they would have to provide financial statements based on national accounting standards of what those programs actually cost. For example, I have a location in Cobb County, in East Cobb. I used to have three. 3 years ago, I had 3 locations. I've had to close 2 of them down because I can't compete with the public school systems at the price that they're charging. We charge $459 for 30 hours of classroom, 6 hours of private in-car training with home pickup for the in-car training portion. And I know that our biggest competitor, in fact, I think they're the largest driving school in the state, is the Marietta City Schools, is the largest driving school in the state. They charge about $100 less than we do for that same program. Over the years, I've taken a look at what it costs, and I've talked to superintendents to provide driver education after school. And as an example, about 3 or 4 years ago, under Governor Sonny Perdue, there were a number of budget cuts. The last budget cut that affected the school systems was the equivalent of about $25 million to the DeKalb County school system. The DeKalb County school system had a QBE-funded driver education program available to all their students, and I don't believe there was any charge for it. Well, when that last cut came to the school system, the superintendent said, we're looking at every single program we provide, we have to cut someplace. And they decided they were going to cut driver education. Shortly after that announcement was made, I spoke to the superintendent about the possibility of Taggart's Driving School providing that program to DeKalb County schools. He said he was a little busy, but he was very interested in it, and he would have a deputy superintendent call me by the end of the week. And that's exactly what happened. And I sat down with the deputy superintendent and the assistant superintendent, told them about our program, and said I could provide a complete turnkey operation for about $425 to $435 a student, because I wouldn't have to pay heat, light, electricity, rent. We would just provide the program. And he told me that it was costing the DeKalb County school system $1,800 a student for that program. And after he said it, he sort of put his hand up to his mouth because he knew he probably shouldn't have told me that information. But it follows because about 15 years ago, in the state of Texas, where they had mandatory driver education, most of the driver education was taught in public high schools, the legislature did a study, and they found that it was costing them $1,100 a student, where the average driving school at that time was charging probably $235 to $245 for the same program. And so the legislature dropped the funding in Texas for high school programs, and private schools took over the program. The same thing happened in California, and where mostly it's almost all private schools now because of the cost of the program. I believe, from the research I've done, looking at budgets online with different school systems, that the schools are able to say, at least someone in the school will say, that they're breaking even or making a profit because they bury the expenses for the program in other budgets. For example, DeKalb County, the insurance for their program, for the driver education program, wasn't included in the budget for driver education. It was in the general budget over here someplace, where private businesses can't do that same thing. When I get a P&L statement for last month, maybe on the 15th or the 20th of the month from our CPA firm, every item of expense, every category is listed. I can't bury it someplace in somebody else's budget. It all comes out of our income, and it either supports it and we stay in business, or we lose money and eventually we go out of business. So the only way we could come up with, as taxpayers and as private industry, to protect our industry, is to perhaps require the school systems that teach programs after school to have to provide, based on national accounting standards, their actual cost. Now, we don't have a problem if a school system wants to teach it during the daytime and it's a QBE funded program with credit. The problem we have is when government goes into business competition against private industry, simply stated.
Committee? Chairman Golick.
Thank you, Mr. Chairman. Mr. Trink, just to, if I heard your ask accurately, it was to have this local school system that wherever it may be, whether it's City of Marietta or DeKalb County or wherever, to be compelled to turn over essentially what their real costs are, and go ahead and turn over the rock and see what's there and what their cost is. Isn't that all subject to open records anyway?
I guess it would be, but if someone had to provide a statement, financial statement, and sign for it, like a superintendent, it would probably be a lot more accurate. I will tell you that in 1998, my company, me, it's a C corporation, but I own all the stock, so I mean it's me. We filed a lawsuit against the City of Marietta and the Cobb County school system for going into business after school providing driver education programs. We used to provide the driver education program for Cobb County, but then they decided they were going to get involved with the Marietta City Schools. I think they provided them back then close to $300,000 to buy cars, and I saw $300,000. Wow, I could teach about 800 kids for that $300,000. I know we could do it for less money. And so we filed suit. A gentleman by the name of Robert Wilson, Bob Wilson, used to be the district attorney in DeKalb County, was our main attorney, and he did depositions. And when he deposed the person who was in charge of the program, she indicated they were making money on the program. When he deposed a couple of people in the school system, in the finance area, that didn't have, shall we say, a dog in that fight, they were just providing information, it was real clear that a lot of the expenses were buried in other budgets, and they were losing money. So, you ask whether it's public record. What we would have to do is go to every school system, I guess, and have somebody who's a financial analyst look at the whole budget to figure out where all those expenses are hidden.
I'm sorry.
I think the responsibility should be put on the school system. First of all, they're going to start a program after school. If there's a private company providing that service in that county, they should probably advertise that to see whether or not they can provide the service at a lesser cost.
Just to follow up on that, I mean, is it your contention that a school system operating any driver's ed program outside the school day is violative of Georgia law?
No.
Okay. So they can do it legally?
Yes, they can.
How do we, and I can understand your angst, and if I were sitting in your chair, I probably would feel the same way. That being said, is it our proper role, and I'm asking this sincerely, is it our proper role to start getting into the DeKalb County School Board budgeting system and what they're doing and why they're doing it? Isn't that really more of a grand jury issue, not grand jury from a criminal standpoint, but grand jury from a good governance standpoint? We have those grand juries convened all the time in various jurisdictions about our public resources being used in the most accurate way possible, rather than us getting involved in what they can and cannot do. Are they spending, DeKalb County taxpayer money appropriately, City of Marietta taxpayer money appropriately? Is that a state overstep if we were to do that?
I can see that approach to it. But
Since it's open records anyway.
Yes, I don't think you're getting into their business, because the legislature already sets rules and guidelines under QBE, what school systems have to do, what any government agency has to do with respect to reporting. And you wouldn't be involved in it if the report had to go to the state superintendent of schools. And it was available once the report was prepared, then any citizen could actually go in there and get a copy of it. So,
I mean, that's a point well taken. It is, sincerely. It's just a matter of, okay, and we compel all kinds of reports coming from the local cities and counties of the state. I get that. We get that. I just wonder, it's one more report on a very finite piece of business, a very particularized, unique, specialized, piece of business that jurisdiction A, B, or C may or may not be into. Yes. We go ahead and do that in this particular area. Where does, what's next?
Well, I don't think a school district is involved in any activities that affect private industry, except in this particular area. Not that I'm aware of.
That's a good question. Thank you, Mr. Chairman.
Okay, Representative Powell.
God knows I'm not a judge, but I understand that for me, it's like black and white. As a law enforcement officer, it's hard to agree with violation of the law. Let it go to court. And it's the judges, this judge will just use it in the court to decide whether they're going to get very guilty and whether you pay whatever the fine or whatever. But it shouldn't be in the ground jurisdiction. But then you start getting into other schools and things like that. It's pretty aware that all of a sudden some people got switched because of that. We may very well be on the verge of these licensed state institutions or schools and stuff will be prevention driving, DUI, or driving through. They're not going to survive. They're not going to be like state students. A lot of them don't survive under that practice. This to me, background is we have been very cautious of years in driver services, basically monitoring the licenses group. So we did one, we did one situation. We did one club in Georgia selling course certificates, and that used to happen. It used to be 25 or 30 years ago. It used to be pretty prevalent. If you got a DUI, you were going to the DUI streets, you get multiple certificates and something. And we pretty well shut that down for the legal enforcement over the years. But we also have a lot of respect for the private schools. So maybe what we're looking at is all business that we need to look at. That's the competition that the government in itself is competing with the state. And if we continue to grow with the state, lower amount of the school, or the lesser number of the schools, will be a base. I think that's what the current cycle is about.
Thank you, Mr. Powell. Chairman Gold.
Thank you, Mr. Chairman. Just a couple of, not necessarily responses, really just an observation or two. I mean, it seems we have two main issues. One is the competition issue, and the other is the judicial or just the discretion issue in general. Again, I'd remind folks that any sort of pretrial program is really run by the prosecutor, really, and the judge has to accept the recommendation, but generally that's the discretion of the prosecutor. It could be a DA involved in it where you don't have a state court, don't have a solicitor, especially in more rural jurisdictions. Separating that out for a minute, I mean, the competition issue is such that, again, I think it gets back to the question I asked Mr. Schrank, and where you have the city of Marietta or DeKalb County or whoever it may be, if they're using public resources, to run driver's education, let's put it this way. Let's presume for a minute, hypothetically, that from a fiscal management standpoint, that they're doing it in a responsible way, that they are being good stewards of taxpayer money. They're making a policy decision on the local level that we're going to take this money and we're going to dedicate it toward driver's ed because that's what our constituents want. Fine. And they're doing it in a fiscally responsible manner. And they're doing it for a price that, candidly, is clearly undercutting Mr. Schrank and his business, correct?
Yes.
The question is, who are we, and do we get in the way of that situation, assuming it's compliant with Georgia law? And what do you say to the taxpayer who's saying, well, I kind of want my local system, and they may or they may not. I don't know. That's not the issue here. I want my local system to go ahead and do this. I find it, it's a more competitive rate. I'm getting bang for the buck. It's going to save me X amount of dollars in a recessionary economy, which actually matters these days. And that's what I want. And if that's what they want, isn't that between, and this is really more rhetorical, isn't that between them and their local school board member in terms of making that policy decision of to be in this or to not be in that? I mean, and I'm not expecting an answer to that. I just think I'm just trying to frame a question. It helps me get my head around the issue, first of all. And number two, I think it does frame the issue going forward, Mr. Chairman, and something that was potentially going to make a policy recommendation on. Thank you.
Do you have any other comments,
Yes.
Bob or Barry?
Chairman Rice and Chairman Powell had introduced, I think, 5 bills last year. There was one big omnibus bill, and then they separated into 5 separate bills.
Let me just preface this for the this is not the Judiciary Committee, and it's not the Motor Vehicles Committee. This is just a committee that is studying the issue and attempting to come up with a recommendation that we can agree on with regard to the issues that are being confronting us. Mr. Schrank has provided this particular document, which summarizes 5 bills that we chose not to pursue last year in light of the fact that we were going to form the study committee and spend more time on the issue. But what we've done is to summarize what those 5 bills are, and these are the bills that basically the private school industry is presenting in terms of improved ways to or ways that are more fair or level the playing field within this driving school sector that we've talked about, public or private. And so I don't want the committee to take this as the Rice-Powell posture. This is basically what the school owners ask us to put together, and so it represents their view of what the legislation would be, and it gives us a straw man as to something to work with. And so with that, why don't you just quickly outline what these are for the committee, and then we're going to move on, and we're going to come back to the issue of the court school sponsor schools or provision schools, and then anybody else who wants to comment on the private driving education schools.
Okay, thank you, Mr. Chairman. Basically, with the 5 bills, some of the bills contain changes, wording that appear in the other bills. So there's really no, my way of looking at it, rhyme or reason why it's that way, but that's the way the Legislative Council drew it. And I'm sure the sponsors had a reason for that. But one of the items, let me back up. Basically what I talked about with the school system competition and the court competition, that appears throughout all 5 bills, different issues. Something that we did not talk about, as mentioned earlier today when the panel was up here, is House Bill 1136 from last year. It requires a completion of the risk reduction program within 120 days from conviction or release from incarceration. I think when I'm talking about the interlock bill, the risk reduction program is a key part of rehabilitation, getting people, changing people's behavior. And what happens now basically in a lot of jurisdictions is that once the individual has been convicted of DUI, they're supposed to attend the risk reduction program, but they don't for a variety of reasons. Now the probation officer is supposed to insist that they attend, but often what happens, and it's probably politically unpopular to say, but the private probation company is more interested in getting their fee every week or every month than they are in the person spending that money and going to the DUI risk reduction program, which is the first step necessary in changing their behavior. The first step necessary before maybe they go to treatment or go to whatever program they're involved in. And we suggest that the law be changed that while they are on probation, that they're required to take that within 120 days of DUI risk reduction program. And of course, the probation officer would have to enforce that particular item if that was included. That would be very helpful when you're talking about the issue of driving without a license, because to get their license back, they have to attend the risk reduction program. And a lot of these folks, if they don't have somebody with authority telling them they have to do something, they're just never going to do it. And they're just going to continue to drive, and they get caught, they go to jail, they get caught again, they go to jail. It's just no big deal to them. So I would suggest that 120-day provision is very, very important. 1137, all of our fees except for driver education programs are set in code. And for example, the 6-hour defensive driving program is $75. We were asking for a fee increase to $95. That fee has not been increased, I believe, in 10 years. The fee for the assessment, which is something you take before you enter the DUI risk reduction program, I believe that is now $82. We're asking that goes to $85. Basically, that $2 or $3 is going to go to the provider of the assessment, who hasn't had a raise, I think, since 1990 when the program went into effect. Two other items that we're asking the committee to consider, and that is under 40-5-470 and 40-5-440. Driver education, vehicles that are used in driver education programs in public schools do not pay any ad valorem tax on those vehicles. That bill was passed, that law was passed when there were very few driving schools, and most of the driver education was conducted during the school day, and they were government vehicles. And but we have to pay ad valorem tax. Last year, my ad valorem tax bill in DeKalb County was $5,000, which is a lot of money. To put us on a level playing field, I'm not going to ask that we don't pay ad valorem tax, but what I'm going to ask is that if the school system is providing a driver education program after school and charging tuition for it, that they have to pay ad valorem tax just like everybody else does on their business vehicles, because they are business vehicles. Another problem we have is, at one time, as part of the licensing process, whether you want to get a school license or get an individual instructor's license, you have to have your fingerprints taken. Well, we used to have fingerprint cards. We go to the local police station, and if you were in a small town, they would probably do the fingerprints for free. If you were in DeKalb County or Fulton County, they would charge you $5 per card, or a total of $10. That system changed now, where it's done on a computer by private providers, and it now is $50 and some change to have your fingerprints done. I have to have my fingerprints taken, it seems, about every 8 or 9 months, because I have another license, either a school license or a personal license, that becomes due, and it affects other school owners and instructors as well. And I would suggest we have something in that code section that says that if you have a clean record, that you only have to have your fingerprints taken every 2 years or something, because they don't, I mean, seldom if ever, they find something that's done something wrong by having those fingerprints taken that often. And in today's economy, that $50 is a lot of money. Other than that, I mentioned it last time, and I think it was this suggestion will be borne out by what some of the panel suggested, and that is mandatory driver education. We're seeing a lot of 17-year-olds getting their driver's license now because the parents are saying, don't get your license at 16, and that way you don't have to take driver education, and wait till you're 17, which is what happens. And so they don't take driver education. And I would submit that a 17-year-old is just as dangerous on the road as a new driver as a 16-year-old. And perhaps we should take the next step and require those under 18 years of age to take driver education. Basically, ladies and gentlemen, I believe that's all that I have, unless anybody has any questions.
Questions? Apparently not. Well, thank you so much for coming in. We appreciate it. We're going to, it's noon, we're going to go another 30 minutes, and then why don't we got a choice here. Why don't we, Judge, I know you're dying to get back to your courtroom. So why don't we just go ahead and move back to the court-sponsored probationary classes and things like that. You wanted to talk about the AARP thing, I think. Did you not? Well, okay, all right. The floor is yours. Why don't you guys let the judge come up and?
Yes.
Right. Okay. All right. Also, Judge, there's somebody from the DeKalb Solicitors Court here too, and who would that be?
That would be me.
That'd be you. Okay. Why don't you just tell us your name too? Keisha. Okay. All right.
Mr. Chair, members of the committee, I'm Gary Jackson. I'm a full-time judge in Atlanta Municipal Court right down the street. And am I on? I just wanted to set the record straight that my testimony before this committee last time it met has been mischaracterized. I have never and will never allow or order anyone to attend a defensive driving course that is not approved by the State Department of Driver Services. In fact, if you come into my court, I make the same opening statement actually twice a day, that if you are ordered to go to defensive driving, you must attend a course approved by the Department of Driver Services. For you senior drivers, AARP is not on the current list, and I'm working to change that. So the previous speaker's testimony is just simply incorrect. What I do tell drivers, particularly those coming back to court on high-speed cases, for example, I would suggest you attend a DDS defensive driving school, because if you lose the case under 40-5-57C1C, you may be eligible for a points reduction and a minimum 20% reduction on your fine. And my general habit is, if you're at 80 or higher and you lose the case or plead guilty or whatnot, and I generally don't accept NOLOs at that level, that's just my personal belief, and it's discretionary, and at that level you're pretty much left the discretion out on the road. But if you will take that course, and I generally order people to do so, that you will more than likely get the 0 points order. You will get at least a 20% reduction, frankly often more, and you may qualify for an insurance deduction of 10% discount depending on your record. That's between you and your carrier. But I make it a specific point to say that the courses have to be approved by DDS, and that AARP is not on the list. In fact, that is why I stayed late the last time to testify and urge that some exception be made for DDS, because I've taken that course 3 times myself over the last 5 or 6 years. It is addressed to senior drivers. It's very inexpensive, and it's extremely effective. The only other thing I'd like to say about driving courses, we have a teenage learning control system in our court. It is part of the Solicitor's Pretrial Intervention Traffic Program, which the legislature authorized municipal courts less than 2 or 3 years ago. In my particular court, I use it as a sentencing module. And yes, we do offer some type of driver training in the courts, but we also require that the teenage driver attend a DDS course, which of course is approved outside of court. So that's a mischaracterization as well. I would add that our success rate, and I measure that by how many of these drivers we see again, 95 to 96% of all of our teenagers who come through our TLC program, and we have 4 different levels, we never see again. I can count on one hand the number of repeat teenage drivers who've been through our TLC program that I've seen this year. I think it's 3. Very, very rare that we have a repeat offender. So our in-court TLC program, training program, is extremely successful. In fact, it's the most successful program that we have. But as far as courts are concerned, we're still working on our Title 40 revamp. I could go into some detail. We're looking at 4 different classes of cases. Level 1.
I think we're going to.
That's going to be deferred till later.
We got 2 more meetings scheduled.
We've got
I think we're going to hear on that.
For that. But as far as training, we're strictly DDS. We do have a teenage program, and you've already heard my testimony why I think AARP would be a good add to that. And I was planning to stick around later, but my testimony hasn't changed. It works, and I would urge that an exception be made. And yes, it is competitive with private schools. Don't have to be a AARP member, but it seems to work. And the bottom line is safety on our roads, as Judge Anderson testified earlier. Keep people alive. We're at 1,001 fatalities. I saw as I drove back from Auburn, this weekend, the Emerald Message boards across the interstate, and we we are into that season where we're really hoping we're going to raise that number. And it's been, as the governor's highway staff, safety staff testified, that number has been dropping. The bottom line is keeping people alive on the road. And for me, AARP works. I just did want to set the record straight. That was not my testimony. It never will. And I'll answer any questions.
Any questions for Judge Jackson? I don't see any. Thank you, Judge, for coming.
I don't need to return for AARP because you've heard my testimony before.
Oh, I think we're going to see you again probably when we
We're
do
working very,
reclassification
very hard,
stuff.
particularly on the tax intercept program that we're looking at. So thank you very much.
You happy or sad when you were coming back from Auburn on?
Oh, extremely happy. Extremely. In fact, there was no traffic jam at all. Those of us who stayed, it was a red little corner, and that was it. No traffic jam at all. We were very, very pleased, and we observed the speed limit on the way home. Very carefully.
All right. Well, Ms. Story, I thank you for coming today, and why don't you tell us what you do and tell us about your thoughts on this issue with respect to DeKalb County.
Sure. Thank you, Chairman, and thank you, committee
And
members.
who's your friend here?
Stephanie Woodard, Solicitor General, Association
Ah,
President. And
okay.
that's standing in for Mr. Spahaus for the prosecutor.
Okay. Would you convey to him our sorrow that we didn't get to him, our apologies we didn't get to him as in a timely matter?
You were glad to have me on staff.
You know, that's probably a better way to put it. I don't have my.
Yes, Chairman, I will.
Okay.
All right. Good afternoon. I'm Keisha Story, and I am the Deputy Chief Assistant Solicitor General in the DeKalb Solicitor General's office. My position is essentially over our diversion unit. We have lots of diversion programs, but here particularly to talk about the pretrial diversion program. I'm here to, of course, represent Cherry Boston's office. I cannot speak to what Recorder's Court, DeKalb Recorder's Court is doing and what programs that they have, because that is actually not my office. That's the DeKalb District Attorney's office that has prosecutors in the Recorder's Court. So anything that was said about Recorder's Court or programs that they have or what they're doing there, I cannot speak about that. But can talk about what the DeKalb Solicitor General's office is doing as it relates to the traffic diversion programs that we have. We do have a pretrial diversion program that will take select traffic offenses that where a person has little to no driver's history, little to no significant criminal history, that we feel that would benefit from the rehabilitative nature of our program. It's essentially, in lieu of prosecution, we offer an opportunity for certain defendants to complete programming. A lot of times that includes community service, other personal help classes that are adjusted to the facts or the nature of the offense. For the traffic cases, it's normally speeding cases, running a red light, running a traffic light type of offenses. One of the programs that we do offer or suggest that individuals take is a Teen Victim Impact Panel. It's not a driver improvement course or a DBS approved course. It's not for driving. It's not a defensive driving course. It's a Teen Victim Impact Panel. And we have found that program has been highly successful. The person that runs that program came and actually showed us the program, and the judges in our circuit actually looked at the program, and we found that it was beneficial. It's geared towards teen drivers and addresses issues such as texting while driving, racing, some of the other issues that teens deal with, just having distractions in the car. It deals with not only the drivers, but also the teen passengers in the car and how they're to conduct themselves to avoid traffic accidents and fatalities. Compelling in his program is he actually has live victims come, or people that have been affected in some way by texting while driving or racing or those types of offenses, to actually come and give a human perspective as to how the behaviors actually affected their lives. I know that at one point he has an amputee, a child that was, I want to say, on the cheerleading squad that had her leg amputated because of a racing accident. So she comes, or her parents also sometimes come, and just other different personnel. I know that he also brings in first responders and law enforcement officers to talk about some of the things that they've seen on the road. So we found that this teen victim impact panel has been effective in those types of cases. Our pretrial diversion program is a prosecutor-run program authorized by the statute. It's not a judicial court-ordered program. There is actually, if you saw our agreement, and I'm sorry I didn't bring a copy of our agreement, but there is actually not even a place for the judge to sign. This is completely run by the prosecutor's office. And like I said, it's a program given in lieu of prosecution. I do not believe that any sentences that are any court-ordered sentences that our assistant solicitors are a part of on the trial line are given TVIP or any other program in lieu of an approved DDS school when it's warranted for driver's license reinstatement or for risk reduction or anything like that. Whenever those driver improvement schools or risk reduction programs are warranted because of the sentence or because of the charges, those are actually imposed, to my knowledge, by the judges. And the other things that we do, like TVIP or the other victim impact panels, are given or imposed in addition to any DDS approved or risk reduction.
Okay.
If I may, Chairman.
Sure.
Of course, I speak for all of the Solicitor Generals in the state from the association, and that, by nature of being there, means they have a state court that has jurisdiction. Chairman Golick's comments were exactly correct that there are rural jurisdictions where there is no state court, and the district attorney's office is overseeing traffic cases. The Superior Court judges are hearing those cases as well. So there are differences statewide. DeKalb's an anomaly. It's the only county in the metro area where the DA's office is actually handling reporters' court in the traffic. And it's one of those situations where it's always been that way. I don't know why. There is a Solicitor General in DeKalb County. But that is a different prosecutorial body that's handling reporters' court and the Solicitor General. Normally from Traffic Bureau, if a county has a Traffic Bureau, they demand a jury trial that goes over to the state court, and that's where the Solicitor General's pretrial diversion program is specifically begun there. In rural jurisdictions, where it's always been with the district attorney's office and the state court, the same prosecutors do it from beginning to end. Here's one of the problems with looking at only one jurisdiction when addressing legislation. The way things are done in small rural areas aren't the way they're done in more developed counties or in the metro areas specifically. For example, in Hall County, we don't have pretrial diversion programs for speed reductions. In fact, we do it. My defense counselors in our jurisdiction will tell you I'm draconian. They enter a guilty plea. They're on probation for 12 months, during which time period they do a court-ordered but DDS-approved driver's education, and I run their driver's history at the beginning, in the middle, and at the end, and I keep a list. If you've had one points reduction in Hall County as a teen driver, you'll never ever have another one. So there are different circumstances, and when we're looking at changing legislation in response to someone's concern with one jurisdiction, I have great concern, because every county and every jurisdiction has different pressures and different concerns. This is one place where I think Chairman Golick's issues about separating the two come back, have a common issue, and that is if something's not working in a local area, in something like a pretrial diversion program, it's something for local constituents to look at in electing that prosecutorial representative. I will tell you that pretrial diversion programs are never court-ordered. Those are specifically pretrial negotiations between a defense attorney and the prosecutor, or the defendant and the prosecutor. In my jurisdiction, all pretrial diversion programs, my assistant solicitors who are evaluating the cases look at all of the dynamics that are going into it. Was it distracted driving? Well, in driving is a difficult situation because I don't have pretrial diversion for point reduction cases. But they look at all the totality of the circumstances and negotiate and agree. Substance were an issue. Previous dating relationships, things were an issue. And they negotiate specifically what are the pretrial diversion. The only thing a judge signs is the null pros. And the only response the judge can have to that is to refuse to accept the null pros, which forces a trial or forces a different plea negotiation. So that's one of the things that I wanted this committee to understand, is that in pretrial diversion, that is not, the judge has no portion of that. That is completely between the prosecutor and either the individual or the defense counsel. And the judge is simply accepting the null pros or dismissal of that case. It's a little bit confusing in that aspect, so that's why I wanted to make sure. And bring concerns from, I'm happy if this committee is interested to see what is, to gather the information from the prosecutors about what the different programs and what the different jurisdictions. You have 150 counties, and I dare say in your jurisdiction and in the different circuits, you'll have many, many different ways tickets are handled, pretrial diversion programs are handled, reductions are handled. Is there any questions that I can answer for the committee?
Sorry.
Thank you.
I don't see any, Stephanie. Thank you for commenting. Let me just take a minute and look at this one thing I may have a question on. Thank you. I don't have any question. However, once again,
basically, my understanding of talking to her twice, about these things, they operate pretty much the same way other students in this county. If there's a pretrial verdict program, that's negotiated between the prosecutor and the defendant. And there may be a program running through their probation office that monitors that and handles that, makes sure the defendant complies with what the pretrial verdict program did. It might be with its driving course, there might be some other courses that the court tailored to their individual situations. The judge is not ordering to say, this court, this is approved, that court is connected, that's not happening. Furthermore, anything the pretrial judge does not deal with, it's part of the court, it's not dealing with the court's reduction situation. That is only dealt with by licensed private students. If they're ordered to go to those students, it's not good for a licensed private student, it's trying to operate for somebody else operates. So if they have DUI and need to go to a course for the license back, if they have a speeding ticket, they have to go to the driving course, that they can't do that through the court. The court supervisor goes, I have to go to a licensed state program. And just to make it clear, they are not, just got to work their mind with that, they're steering people to this particular course, that particular course. They're not. The only time anything remote like that happens is they go for a pretrial version through the probation office, and they have some courses in that regard. If you're trying to report to use for speed use, report to use for DUI, somebody's your license back, corrective driver, somebody's your license back, you don't have to go for the license program. They tell you if you're free to, as long as you're licensed by the state, you can go going forward. So I will make that clear.
thank you, Mr. Powell.
To be sure I'm understanding what you're saying. Maybe I don't understand what pretrial verdict is. I understand that like you're charged with things. When you go through pretrial verdict, basically you do what court order and the agreement was made for pre-trial verdict, then that does not go forward. That offense is basically.
Case of law, Frosty just mentioned.
Alright.
And
So,
pre-trial, President Powell, pre-trial version, they just said it involved many things. They may say, depending what the charge is, they may say, go to offensive driving class, go to a DUI class, or not, depending what your offense is.
I understand. So I was correct about what a pre-trial diversion is, or one of these types of diversion programs.
Right.
So,
Respectfully, if I may, it's not court ordered, because the judge isn't involved in that system. So everything other than the court order
and
is.
the judge is always at the end of it. He just has to stamp off the agreement and prosecute it.
Yes, sir.
Right. So, I'm sorry, completely around this is Terry Goldie trying to do what I go. So if under these pre-trial diversions, while the judge doesn't order them, that is terms of the agreement with the defendant.
Prosecuting it.
Right. So it doesn't go forward into the record to the stop basically. When you run the red light and you have a speeding violation, so we're going to submit you to this 12-month probation if you're in driving. I presume you're going to drive.
Yes, sir. Yes, sir.
Which is pretty hard on some of these things that are written out of sticker. My district. Yeah. But fair to say, I think what we're getting to here is that it's still, it's sort of circumventing the purpose in driving competition to these state licensed schools that's been doing the defensive driving. But while they might prosecute as part of it, they may don't do the license to the end, they may not. So if they're steering to enforce some of these county employees to teach themselves.
And if I may, I'm concerned about finding out what the specifics are, because what Ms. Story's indicating is that is, if it's a point reduction, they do the teen victim impact in addition to the DDS score. And I'm aware that in Reporters Court, we've gotten an email confirmation from District Attorney Robert James that there are no ADA taught driving schools. So I'm concerned that if this body is concerned about a specific jurisdiction and what they're doing in some abuses, calling that body in and questioning on that. Because the general practices I see statewide, there are no other than, I would never send someone to something other than a state-approved driving class where that was warranted and based on the facts of the case. So I'm concerned that what they've heard is perchance the teen victim impact, assuming that's the only thing that's being sent. And my understanding is that's not true. Where it's a driving offense, there is a DDS-approved school as well as the teen victim impact used when that's approved. I could be wrong, but that's why I think the danger is in addressing statewide concerns from one jurisdiction and not exploring fully that jurisdiction and what their practices are.
It's pretty difficult to get our hands around this thing, isn't it?
Absolutely.
This Kyle, one thing to keep in mind is prosecution they're pretty safe. A lot of school members know you have a chance. They don't have to do anything. They can if they want to. Sometimes they're trying to negotiate their path. A lot of them. But they can say, no, I don't want to have to take all these courses. I don't want to do good. So they may just get mad.
They also can say, I want my child.
Nothing very simple about it anymore. It's got to a lot of uniform that attorneys have.
Finished? Chairman Goley. Okay, any other questions from committee members of the great people we got here? Thank you so much for coming. There's is there anybody here from area public schools? Y'all want to come forward, tell us who you are? Okay. All right. Well, good. I knew you would. Thank you. Why don't you tell us all who you are?
I am Cindy Savage. I'm the director of Marietta Community Schools, a division of Marietta City Schools.
I'm the Director of Communications for the school district. I'm the spokesperson for the district at large.
And your name is?
Thomas Alderin.
Thank you. Go ahead, Sam.
First of all, I just want to say I only heard about this meeting on Friday, so I'm only prepared to talk about what I've heard here today. But I do want to give you a little bit of information about us. Marietta Community School, as I said, is a division of Marietta City Schools. We are a fee-based program that we offer classes, enrichment classes, for adults, teens, and youth after the regular school hours. We offer adult classes at night. We have, since we've added online courses, we offer them cheaper than Kennesaw State University, Southern Poly. We offer after-school programs for children. We offer them cheaper than child care centers that are out, in the public. And then we have our driver's ed program that's a component, and all these are underneath an umbrella of Marietta Community Schools. We do not use general funds for our operation. It's all fee-based. We had a lawsuit from Taggart's that we took all the way to the Supreme Court, and we did win it. After that, he went to the legislative and asked for a $150 tax credit for private companies, and public schools could not get that tax credit for their parents, from their parents, or for their parents. And that brings his course actually down below what ours are, or what we charge. So the DDS has used us as a model for other driver's ed courses in the state. We actually received one of the Governor's Office of Highway Safety grants, which we use strictly for scholarships for children. We have done very good work. We are probably the largest in the state. I haven't checked with Gwinnett County lately, but we are probably the largest in the state where we educate children. When I was listening to Mr. Blackwood talk, it just seems like this is a very conflicting thing here. I'm very passionate about this. I love to educate children. I love to keep them safe on the roads. I'm not about making money. But he said that we're in need of more training for our teens. We need to look for any opportunities for more training. So what he's proposing, or what he's saying here, is that we should cut out schools. And my business is schools. I teach children. So I know that this is a very gray area, and I know that but I think the court system has settled it, and I think that he did something later in legislative to kind of even it all out, and so I don't know why this issue's coming up again.
Questions? Are you getting ready?
I just want to just to make sure it's clear that there's no taxpayer money involved here in what in the program that you
My budget
conduct.
is separate from the general fund of Marietta City Schools.
Mm-hmm.
It is very clear. It is in open records.
Yeah, and there's no taxpayer money. You said there's no general fund. There's no other taxpayer funds involved. You said it's all fee-based from the individuals.
Right.
And it seems that the system is simply more the facilitator, for lack of a better term, for for what you provide.
I
Is that
pay
right?
funds for the facility used to Marietta City Schools.
Okay. Okay. Thank you, Mr. Chairman.
Another question: do you qualify under Joshua's law for any of the grants that come from the state in terms of vehicles or anything like that?
Yes.
Okay, so there's public funds.
Well,
In the Marietta
I
County
did
school
get one
system.
of the grants, and it was used for scholarships. I didn't use it for cars.
Okay, scholarships. So
Children that are on free or reduced lunch, I used it to scholarship their money to take the course.
Okay, and the price of your courses? Price of your driver training courses?
$385.
$385. Okay.
And with his tax credit that he charges $459 with $150, it brings it down to $309.
Okay. All right.
That's advertised on his website.
All right. Any other questions? Had an amazing amount of commentary today, so I appreciate the opportunity for you to come down and testify today. We appreciate it, Cindy and Thomas. We appreciate what you do, and thank you for doing what you do and protecting our kids. Well, I think that's the last. Thank you so much.
One more thing. I did think of this. I'm sorry. Again, what one other person said, that what you do in one area affects the whole state. Like, for instance, Gainesville State College provides driver's ed, and it's cheaper than my course. It's $365. And there's not very much opportunity up in Gainesville and whatever county that is for driver's ed. So, I mean, there are a lot of different areas in the state that would be very much affected by stuff that, things that are done in this area.
Is it your intention to go out and solicit other locations to provide your services to?
If somebody comes to me and asks me if they're taxpayers and they come to me and they would like for us to provide services, I do look into providing it.
Okay.
If it's in our community, in our local area. No, sir. They have come to me because we're a good program. In fact, Bartow County did.
And they didn't do it on price then, they did it on quality?
I would think so, yes, sir.
Well, okay. Well, on that note, I think we'll terminate the discussion on this and appreciate you coming. Thank you. Is there anybody, we're going to break at this point in time, and is there anybody else that wanted to speak on any of these issues to this committee? Anybody else? Going once, going twice. Don't see anybody. Okay. We have lunch in the back of the room there that is, I hate to say this, but it is provided by Taggart's Driving. No, I'm sorry, by GUARD, the GUARD organization. But I don't hate to say that because they've done a good job of ferreting out some lunch for the committee members and committee aides and so on. I think what we're going to do is we're going to digest the information we've heard today and sort through this, and when the committee comes together next time, which will be really the start of the report that comes from the judges on the reclassification of minor traffic offenses, I'd like to take a little bit of that meeting just to kind of summarize where we are on this and get opinions from committee members on what we've heard today. And if that's okay with the committee members, that's what I'd like to do. If that's the case, then we'll adjourn, and we'll adjourn to have some lunch, and appreciate y'all being here today. Pardon? Judge, if I'll be here. I'll be right back. It might be you and me. So, there is not. No, we're not coming back. No.